Well, got the document now. My payments finally went through. So, continue reading, and I'm going to do better to not read as fast this time. So, bear with me, and here we go. Defendant Netflix Incorporated, through the undersigned counsel, hereby submits an answer and affirmative defense response to the Second Amendment complaint of Angela Corman's files using the same paragraph numbering and headings employed by plaintiff without admitting any allegations contained in those headings. Netflix, in general, to any paragraphs the plaintiff's SAC and the premised on Netflix alleged negligence pursuant to Court May 26, 2021 decision and order on defendant's motion to dismiss. The negligence claim is barred by the First Amendment and was dismissed by the court without waiving an objection. Netflix denies all allegations in the fact, except to admit below. Plaintiff Angela Colborn is an adult residing in Manitowoc County, Wisconsin. Netflix admits that plaintiff Angela Colborn is adult, but without information or knowledge sufficient to form a belief as to the truth, falsity of any remaining allegations set forth in paragraph 1 of SAC and basis denies them. 2. Netflix Incorporated is a foreign corporation authorized to do business in the state of Wisconsin with principal place of business located at 100 Winchester Circle, Los Gatos, California. Answer. Netflix admits that the Delaware corporation that its principal place of business is located at 100 Winchester Circle, Los Gatos, California, except as explicitly admitted herein. Netflix denies the allegation in paragraph 2. Crow Media is foreign corporation domiciled in New York with a principal place of business located at Ventura Boulevard in Encino, California. Answer. Netflix is without information or knowledge sufficient to form a belief as the truth or falsity allegations set forth in paragraph 3, and on this basis denies them. 4. Crow Media, LLC, independent film production company founded by defendants Laura Riccardi and Maura Demos in 2006. Answer. Netflix admits that Crow Media, an independent film production company, but is without information or knowledge sufficient to form belief as to the true or falsity of any remaining allegations set forth in paragraph 4, and on the basis denies them. Crow Media was formerly known as Synthesis Films. Netflix admits the allegations set forth in paragraph 5. Laura Riccardi is an adult residing in California. This is funny. Netflix admits that Laura Riccardi is an adult, but is helped with information and knowledge sufficient to form a belief as the current of the truth, the falsity, and remaining allegations set forth in paragraph 6 of the SAC, and on the basis denies them. Defendants Laura Riccardi and Maura Demos have ownership interest in Crow Media, formerly known as Synthesis Films. They also are executive producers of Making a Murderer 1 and Making a Murderer 2, and film said production while attending the trial of Stephen Avery in Manitowoc County. Defendants Laura Riccardi. Netflix is without information and knowledge sufficient to form a belief as to the truth or falsity of allegations regarding the ownership of Crow Media, formerly known as Synthesis Films, set forth in paragraph 8 of the SAC, and on this basis denies them. Netflix admits that Riccardi and Demos credited as, among other things, executive producers of Making a Murder 1 and Making a Murder 2, and that Riccardi and Demos attend some of all of the trial of Stephen Avery in Manitowoc County, and filmed some of all of that trial, except as explicitly admitted herein. Netflix denies the allegation in paragraphs 8. Statement of facts. Plaintiff Andrew L. Colborn was employed as a corrections officer with the Manitowoc County Sheriff's Department from 1992 to 1996. Answer. Netflix is without information or knowledge sufficient to form belief as to the truth or falsity of allegations set forth, paragraph 9, and on this basis denies them. 10. In his capacity of a corrections officer, he was non-sworn, non-law enforcement officer that had responsibility for security of the jail. Answer. Netflix is without information or knowledge sufficient to form a belief as to the truth or falsity of allegations set forth in paragraph 10, and on this basis denies them. Beginning in 1996, plaintiff Andrew L. Colborn became a sworn law enforcement officer employed with the Manitowoc County Sheriff's Department. Netflix is without information or knowledge sufficient to form belief as to the truth or falsity of allegations set forth, paragraph 11, and on this basis denies them. For the years 2005 through 2007 and all times material hereto between 2005 and 2007, plaintiff Andrew L. Colborn was patrol sergeant with the Manitowoc County Sheriff's Department, hereafter MTSO. Plaintiff Andrew L. Colborn was also a trained evidence technician. Netflix is without information or knowledge sufficient to form a belief as to the truth or falsity of allegations set forth in paragraph 12, and on this basis denies them. On October 31st, 2005, 25-year-old freelance photographer Teresa Hallbach was brutally murdered at the Avery Salvage Yard in rural Manitowoc County, Wisconsin. Overwhelming physical and circumstantial evidence proves that Stephen Avery and his 16-year-old nephew, Brendan Dassey, were the perpetrators of the crime. Neither plaintiff nor any other law enforcement officer planted evidence or in any other way attempted to frame Avery or Dassey for Hallbach's murder. Separate juries returned guilty verdicts against each of them in 2007, and their convictions remain unreversed after numerous appeals. The court records related to the prosecutions of Stephen Avery and Brendan Dassey for the death of Teresa Hallbach, including jury verdicts against them, and their subsequent appeals of their public records to speak for themselves. Netflix denies. Plaintiff's characterization of the court records. Netflix is without information or knowledge sufficient to form a belief as to the truth or falsity of any remaining allegations set forth in paragraph 13, and on this basis denies them. In 1985, 2 decades before murdering Hallbach, Avery was wrongfully convicted of physically and sexually assaulting a woman on a remote stretch of Lake Michigan's shoreline in Manitowoc County. Avery served 18 years of a 32-year prison sentence before DNA testing revealed that another man was the assailant. Under new leadership, the Manitowoc County District Attorney Office promptly stipulated to Avery's release. The court records related to the wrongful conviction of Stephen Avery, his exoneration, and his subsequent civil suit are public records that speak for themselves, and Netflix denies plaintiff's characterization of court records. Netflix is without information or knowledge sufficient to form a belief as to the truth or falsity of any remaining allegations set forth in paragraph 14 of the SAC, and on basis denies them. On December 18, 2015, defendant Netflix released a worldwide distribution of the 10-part documentary series entitled Making a Murder. The series purports to objectively and accurately recount Avery and Dassey's arrest, conviction for Hallbach's murder within 35 days of its release. 19.3 million viewers had watched MAM worldwide. In a January 16, 2016 article, Forbes magazine columnist Paul Tassi described the program as the Netflix most significant show ever. MAM has remained in the national and international spotlight since its debut with renewed interest upon the recent release of Making a Murder Part 2. The original series and the sequel continue to be marketed worldwide and remain available on Netflix subscribers today. Netflix admits that on December 18, 2015, it is released for a worldwide distribution 10-part documentary series, Making a Murder. Netflix also admits that distributor Making a Murder Part 2 and the MAM and MAM2 remain available on Netflix for subscribers today. The content of MAM and MAM2 speaks for itself, and Netflix denies plaintiff's characterization of the content. Netflix admits that the MAM received news coverage, but states that the news reports speak for themselves, and Netflix denies plaintiff's characterization of news reports. Explicitly admitting herein, Netflix denies the allegations in paragraph 15. MAM was and continues to be marketed as a non-fiction documentary. No disclaimer appears in any of the 10 episodes notifying viewers. Well, it's 20 episodes, not 10. Anything but an accurate portrayal of events. In the news, entertainment, media interviews since the program's release, defendants Riccardi and Demos have repeatedly vowed that they were unbiased and objective in their retelling of events, holding the film out as a non-fiction piece. MAM won 4 Emmy Awards, including Outstanding Directing for Non-Fiction Programming, Outstanding Writing for Non-Fiction Programming. Also won 2017 Cinema Eye Honors Award for Outstanding Achievement in Non-Fiction Films made by television. Netflix also accepted other awards for writing and editing MAM. And the employees were congratulated by members of the media for their role in defining a new television genre. MAM and marketing surrounding MAM, including media interviews by Riccardi Demos, speak for themselves, and Netflix denies plaintiffs' characterization of MAM and surrounding marketing. Netflix admits that MAM won many awards, including those explicitly referenced in paragraph 16 of this act. Netflix is without information or knowledge sufficient to form a belief as to the truth and falsity of the remaining allegations set forth in paragraph 16, and on this basis denies them. Netflix employees were producers of several episodes of MAM. Netflix employees were involved in MAM, had made numerous statements to the press regarding their involvement. Further, defendants Demos and Riccardi have publicly discussed Netflix representatives' collaboration with them. One of the producers of several MAM episodes, who is also the Netflix representative to whom Demos and Riccardi apparently pitched this series, described their collaboration with Demos and Riccardi and aligning their vision of the broadcast as mid-melt. Netflix admits that MAM credits Lisa Nishimura and Adam Del Dio as executive producers. Third-party news reporters discussing MAM speak for themselves, and Netflix denies plaintiffs' characterization of the news reports, except as explicitly admitted herein. Netflix denies the allegation in paragraph 17. Upon information and belief, Demos and Riccardi only had 3 episodes in rough cut when they pitched MAM to Netflix. The series had produced and distributed contains 10 episodes that were far from rough in their production. Netflix processes and develops and vetting shows, including documentaries from production through post-production, involves a high degree of involvement from numerous sections of Netflix workforce. Netflix remains an entire job site in which it advertises for employees whose tasks are to assist in content development for shows that debut in its service. Among the other positions, Netflix maintains a position that includes legal review, content, broadcast of the service. Upon information and belief, the final MAM product was shaped with the involvement of Netflix content creative personnel, including but not limited to Chief Content Officer and its head of documentary programming, and it was subject to legal review by Netflix employees prior to release. MAM 10 episodes speak for themselves, and Netflix denies plaintiff characterization of the episodes. Likewise, third-party news reporting discussing MAM speak for themselves, and Netflix denies the plaintiff's characterization in news reports. Netflix also affirmatively denies that the link of what reports to the article from Medium.com process developing vetting shows such as MAM. Netflix admits that it maintains a web page where it advertises job openings. The content of the web page speaks for itself, and Netflix denies plaintiff characterization of the web page. Expert especially admitted herein. Netflix denies allegation in paragraph 18. At no time during plaintiff's employment, MTSO did serve as a spokesperson for the department. As such, he is neither a public figure nor a limited person public figure, as those terms define defamation law. Netflix denies allegations as set forth in paragraph 19. This court holds that Colborn is a public official as the law of the case, which is true because in 2006 he was running for sheriff of Manitowoc County up against Robert Herman, and he lost. But it has nothing to do with this documentary because that came out, 9 years later? Pertinent to the significant aspects of MAM and are not true as represented and are instead false and defamatory towards plaintiff and others. Material and significant facts known to the defendants were omitted and distorted, despite overwhelming evidence proving Avery and Dassey's guilt and utter absence of evidence supporting defendants' accusations of police misconduct. Defendants falsely led viewers to the inescapable conclusion that plaintiff and other planted evidence to frame Avery for Halbach's murder. Defendants omitted, distorted, and falsified material and significant facts in an effort to portray plaintiff as a corrupt police officer who planted the evidence to frame an innocent man. The defendants did so with actual malice in order to make the film more profitable and more successful in the eyes of their peers, sacrificing and defaming the plaintiff's character and reputation in the process. Netflix denies allegations set forth in paragraph 20. 21, attached Exhibit A, incorporated herein by reference, are experts from Making a Murder, episode 1 through 10, which depict numerous inaccuracies and facts, therefore defame plaintiff. There are, in addition, defamatory statements that are further described below. Answer: Netflix admits that the SAC references Exhibit A, which purports to include experts in man, but denies all remaining allegations set forth in paragraph 21. So they're pretty much denying everything. Attached to Exhibit B, incorporated herein by reference, is a transcript of the experts of plaintiff's trial testimony that were included in the MAM episode 5 and 7, but they were significantly altered, as indicated on the exhibit, so as to present a false impression of plaintiff's testimony and to falsely put words in his mouth and omit others. Netflix admits that the SAC reference to Exhibit B were purports to include excerpts from plaintiff's trial testimony included MAM episode 5 and 7. The transcripts of plaintiff's trial testimony are public records that speak for themselves, and the content of MAM also speaks for itself, and Netflix denies plaintiff's characterization of the transcripts and MAM except explicitly admitted herein. Netflix denies allegations in paragraph 28. '94 to '95 telephone call, subsequent alleged cover-up. Defendants Riccardi and Demos, acting jointly in a concert with the other defendants, led viewers to falsely conclude that plaintiff learned of Avery's 1985 wrongful conviction approximately 8 years before he was released, but covered it up. By doing so, defendants created a false motive to plaintiffs to plant evidence, making their essential but false claim that plaintiff or the other police officers framed Avery more believable. Netflix denies allegations set forth in paragraph 23. In 1994 or 95, while working as a corrections officer in Manitowoc County Jail during normal business hours, plaintiff answered a telephone call from a detective in another jurisdiction. Detective asked to speak with Manitowoc County detective about an assault that occurred many years earlier in Manitowoc County. A jail inmate supposedly had told a fellow inmate that he was responsible for assault for which another man was convicted. Plaintiff does not believe that caller mentioned the name of the man convicted of the name of the victim Manitowoc County assaulted. If he did, plaintiff was wholly unfamiliar with these names. Public court records addressing these allegations, including the inconsistencies of the plaintiff and others' testimony about these events, speak for themselves, and Netflix denies plaintiff's characterization of the court records. Netflix is without information or knowledge sufficient to form belief as to the truth or falsity of the allegations set forth, and the SAC regards plaintiff's recollection of these events and unbiased denies them. Plaintiff had no reason to and did not know about Avery's 1985 sexual assault conviction, in which he received a phone call from a detective. He was not employed by the Manitowoc Sheriff's Office until 1992, when he was hired as a corrections officer in Manitowoc County Jail, which remains a separate division within the Manitowoc Sheriff's Office. As a corrections officer, plaintiff was sworn law enforcement officer had no authority to conduct investigations, much less data criminal activity, for which conviction had already been obtained. Doing so would have been a violation of department policy. Accordingly, plaintiff transferred the call to the investigation unit after giving the caller the number in case the call went unanswered or it was lost and transferred. Plaintiff subsequently heard that the higher-ups, Manitowoc Sheriff's Office, had given assurances that the right man had been convicted. Plaintiff had no reason to think otherwise until Avery was exonerated by DNA testing in 2003. Given all the above circumstances, there was no reason the plaintiff to prepare a written report call at the time. The public court records addressing these allegations, including inconsistencies in plaintiff's and others' testimony, and these events speak for themselves. and Netflix denies plaintiff's characterization of court records. Netflix is without information or knowledge sufficient to inform a belief as the truth or falsity of the allegation set forth in paragraph 25 of this act, including but not limited to regarding the plaintiff did or did not know. The basis denies them. Plaintiff first learned of Avery's wrongful conviction in September of 2003 when Avery was exonerated by DNA testing. At the time, plaintiff recalled the 1994-95 telephone call, surmised it may have been related to the Avery case in the direction of Sheriff Ken Peterson. Plaintiff prepared a written statement memorizing the call as part of that. Yeah, but they don't mention that he made that statement the day after Stephen Avery was released from prison. Accurate transport recalling the circumstances surrounding Avery's wrongful conviction consideration by the Wisconsin Attorney General in her independent review. Plaintiff's written statement was promptly delivered to the Attorney General along with all other documents pertaining to her review. The public court records addressing his allegation, including inconsistencies, the plaintiff, it's the same thing. They denies them all. Defendants Ricardo and Demos strategically spliced and omitted portions of plaintiff's trial testimony as set forth in Exhibit A and B, incorporated by reference herein to distort the facts and nature of the 1994 or 1995 telephone call. These omissions and distortions led viewers to falsely conclude plaintiff bears responsibility for 7 of the 8 years he does. Well, they're definitely, somebody should be responsible for that, because if Colborn did in fact pass that information on, then it comes on Ken Peterson. Netflix denies allegations in paragraph 27. For the same purposes, defendants Ricardo and Demos included the second episode of MAM interview with Stephen Glenn, one of Avery's attorneys in the wrongful conviction lawsuit. Glenn expresses dismay that the plaintiff did not prepare a report concerning the call he received in 94-95 until after he was exonerated in 2003. Glenn then mistakenly tells viewers that plaintiff's written statement was kept hidden in the Sheriff's Department safe in 2003 as part of plaintiff MTSO's efforts to cover up their knowledge. Well, if you listen or read the deposition, you get a whole different story of what took place. I suggest you do that. Netflix admits that portion of the interview with Stephen Glenn, one of the Avery's attorneys, in a civil lawsuit against Manitowoc County, are included in the second episode of MAM, which speaks of itself, and Netflix denies plaintiff's characterization of MAM's content, except as explicitly admitted herein. Netflix denies allegations in paragraph 28. Upon information and belief, defendants knew plaintiff's written report concerning the phone call was not left in the sheriff's safe, but chose to include Glenn's mistaken belief in order to further the false narrative. Defendants include intensive experts of the videotape depositions on Avery's wrongful conviction lawsuit at MAM, and upon information he believes reviewed the depositions from the lawsuit and they're entirely determined which portions to include. The depositions include extensive questioning of plaintiff Sheriff Peterson and others concerning the 1994-1995 telephone call and plaintiff's documentation the same 2003. No reasonable person could have concluded from a review of the depositions and the trial testimony that there was anything nefarious about plaintiff's response to the call or his documentation of the same after Avery was exonerated. Nor could any responsible person have concluded the plaintiff's report was left hidden in the safe as part of a cover-up for the Manitowoc Sheriff's Office's wrongdoing. Yet defendants distorted the facts to provide viewers false motive of plaintiff to plant evidence framing of Alabak murder. Answer: the content of MAM speaks for itself. Blah, yada, yada, yada. Plaintiffs called the dispatch on November 3rd, 2005. Teresa Halbach, mother, reported Calumet County Sheriff's Department that her daughter was missing. Police in Calumet County believe that Teresa's last known whereabouts were either the George Zipper residence or the Avery Salvage Yard, both located in Manitowoc County. Halbach had been assigned an employer at Auto Trader magazine to take photos of vehicles that were for sale at each location October 31st, 2005. The last day she had been seen, Calumet County officer requested assistance from Manitowoc Sheriff's Office since Halbach's last known whereabouts were in Manitowoc. Public court records addressing these allegations speak for themselves. Yada, yada, yada. On November 3rd, 2005, plaintiff Andrew Colborn was working a regular shift, patrol sergeant. Yeah, you worked from 12 to 8 that day, but he decided to work overtime. Wonder why. Manitowoc County Sheriff's Department, when he received a call from a County County requesting assistance to a missing person, that evening, plaintiff was asked to check out 2 potential residents where Hallbach reportedly had been. The Avery Salvage Yard and a Zipper residence. Yeah, but he just happened to drive right past the Zippers and go right to Avery's. He was definitely at the station when they called him, because the dispatcher had to transfer him over to the dispatch commander. Public court records addressing these allegations speak for themselves, blah, 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 blah. On November 3rd, on 5, plaintiff called dispatch confirmed the make and model, license plate number of the missing person vehicle, as he had done in hundreds of other cases during his career. Neither the plaintiff nor any other police officer had contact with Hallbach's vehicle on November 3rd or any other time prior to November 5th, when it was discovered at the Avery Salvage Yard by a volunteer search party. The public court records include papers Avery filed in April. The Wisconsin Court of Appeals addressing these allegations speak for themselves, yada, yada, yada. A central part of Avery's defense at trial was the plaintiff and other Manitowoc officers planted Hallbach's SUV at the Avery Salvage Yard, where Avery resided in the house and trailer. The plaintiff, on the stand, Avery's attorneys played portions of his call to a dispatch in an effort to convince jurors that he came upon an SUV at an undisclosed location on November 3rd, 2 days before it was found at the Avery Salvage Yard. Cross-examining the plaintiff about the contents of the call, Avery's attorney suggested the plaintiff was looking directly at the Hallbach's vehicle when he called dispatch. The claim is entirely baseless and false, and defendants knew of its falsity. Netflix admits an essential part of Avery's defense trial was plaintiff or other Manitowoc officers planted Hallbach's SUV, Salvage Yard, where Avery resided. House trailer further states that the public court records addressing the allegations speak for themselves. A side-by-side comparison of the trial transcript with the scene is depicted in episode 5. MAM reveals the defendant's recording demo in concert with other named defendants, heavily edited portions of plaintiff's testimony in order to manipulate viewers to falsely conclude that he and another officer planted Hallbach's SUV at the salvage yard. Among other distortions, defendants removed plaintiff's affirmative answer to one question and inserted it as his answer to a separate question. At the actual trial, the second question remained unanswered after the court sustained the objection by state. MAM redemption of the testimony is as follows. Avery's attorney. Well, you can understand how someone listening to that might think that you were calling in a license plate that we're looking at on the back of the 99 Toyota. Yes. An actual trial, the court sustained state's objection and the defense counsel rephrased it as follows. This call sounded like hundreds of other license plate or registration checks you have done through dispatch before. Plaintiff answered in the affirmative, yes. Trial transcript, day 7, page 186 187. Defendant submitted the plaintiff's affirmative answer to the second question and inserted into his non-answer to the first. Their manipulated of their crucial line of testimony falsely conveyed the viewers and plaintiff located Hallbach's SUV somewhere other than salvage yard days earlier and likely assisted law enforcement officers planted there later time. The impression is false and gives viewers exact opposite impression of the plaintiff was asked how he responded at trial. The transcript of the trial, Stephen Avery for murder of Therese Hallbach, are public records, speak for themselves. Number 35. Defendants Riccardi Demos, in concert with other named defendants, admitted additional trial testimony from plaintiff about the routine nature of his call to dispatch. When asked by the prosecutor to reject examination, Mr. Strang, defense counsel, asked whether or not it was common for you to check up on other agencies, or perhaps I'm misphrasing that, but would you are assisting another agency, do you commonly verify information that provided to you by another agency? Plaintiff answered, all the time. I'm just trying to get, a lot of the times when you're driving a car, you can't stop and take notes, so I'm trying to get things in my head. And by calling the dispatch center and running the plate again, I got it in my head who the vehicle belonged to, and that's what type of vehicle the plate is associated with. Transcript, yada yada, same answers for everyone. Defendants Riccardi and Demos admitted the plaintiff's call to dispatch his words, see if it comes back to. The phrase was included in the actual recording of the call as well as recording played at trial. Upon information and belief, defendants admitted the phrase because it supports a reasonable interpretation of the reason the plaintiff's call that contradicts the impression the defendants intend to make. The transcript from the trailer end speaks for itself, blah, 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 blah. Defendants Riccardi and Demos strategically spliced reaction shots of plaintiff appearing nervous and apprehensive at trial into other portions of his testimony where he did not appear nervous or apprehensive. In fact, the edits were part of a defendant's overall attempt to manipulate viewers to falsely conclude the plaintiff and other Manitowoc County officers planted Hallbox SUV at the salvage yard. Episode 5, in addition, defendants also included MAM Episode 5 as out-of-the-court interview with Avery's defense attorney, Jerome Buning, in which he states if they would be willing to go to that length of planting the key, which I think the jury is going to get by including this in the broadcast, defendants presented it as a foregone conclusion that the police allegedly included plaintiff planted the key at Avery's residence. The content of MAM speaks for itself, and Netflix denies plaintiff's characterization of MAM. To the extent remaining allegations set forth in paragraph 37 of the SAG and are respected to Netflix, Netflix denies the allegations. That's a different response. Upon information and belief, defendants Riccardi and Demos filmed an entire trial were aware of the full line of questioning concerning plaintiff's call to dispatch as well as the significance with the malicious intent. Defendants chose to fabricate plaintiff's testimony by slicing, admitting these portions were not consistent with their misleading and false account of the facts. In truth, plaintiff did not discover Hallbox SUV at another location and help others plant it on Avery's property. MAM aspersions that he did are false and have caused irreparable harm to plaintiff's reputation worldwide. Netflix is without information or knowledge sufficient to form a belief as to the true or false is the allegations set forth in paragraph 38. Riccardi and Demos filmed the entire trial and they were aware of certain lines of questioning and their significance on the basis denies those allegations. Netflix is without the information and knowledge sufficient to form a belief as the truth or falsity of the allegations related to the plaintiff's Hallbox SUV on the basis denies them to the extent remaining allegations set forth in paragraph 38 are with respect to Netflix denies allegations. Defendants also include portion of the interrogation of Stephen Avery in which an interrogating officer says Avery, so Tammy told you that somebody told her that a cop put Teresa's vehicle out on your property. Avery responds, yeah. Then the scene cuts immediately to a visual plaintiff testifying in court. Well, that's because shortly after that, Fassbender and Wiegert get up and leave the room because they didn't like to hear that. The content of MAM speaks for itself, and Netflix denies plaintiff's characterization of MAM. Netflix denies the remaining allegation in paragraph 39 of the SAC. In order to enhance the significance of plaintiff's alleged off-site discovery and subsequently planting of Hallbox vehicle, defendants manipulated facts to convince viewers that the Manitowoc Sheriff's officers, possibly including the plaintiff, secreted Avery's blood from a vial still kept in evidence from his wrongful conviction case and planted it in a Hallbox car. Defendants dramatically reenacted the vial's discovery in a clerk's office by accompanying one of Avery's lawyers to film the retrieval of the vial. MAM Episode 4 contains a close-up shot of the blood vial with a small hole on the top of the rubber stopper, while Avery's attorneys rejoiced in gotcha moment. In truth, the hole in the blood vial rubber stopper is not indicated evidence tampering. It is made the ordinary course of drawing a blood specimen from a person storing in a vial. But the fact that there was dried blood on the inside of the vial leaves me to believe that the rubber stopper was pulled out and then air was able to get inside, which then caused it to dry. But that's just my belief. I don't know. Just my opinion. In truth, the hole in the blood vial rubber stopper is indicated of evidence tampering. It was made in the ordinary course of drawing blood specimen from a person and storing it in a vial. The hypodermic needle hole in the case, which was made by a specimen of Avery's blood, was drawn by phlebotomist and stored in a vial in connection with the 1996 post-conviction motion in wrongful conviction case. Procedure initially resulted in the creation of a hole in the rubber stopper. Phlebotomists who drew the specimen in Avery 1996 were prepared to testify what happened in this instance. Having attended the trial entirely, defendants Riccardi and Emos were aware of the routine nature of the hole on the vial's rubber stopper, and the phlebotomist who drew the specimen from the Avery was prepared to testify. Defendants manipulated the facts and significance of the blood vial discovery as part of their overall effort to convince viewers, the plaintiff, and other county law officers framed Avery for murder. The content of MAM speaks for itself, blah, 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 blah. The key. Defendants jointly, severely, and actual malice led viewers to the inescapable but false conclusion that plaintiff and MTSO James Link planted the ignition key for Hallbox SUV in Avery's bedroom. They did so by splicing trial testimony, omitting other testimony, and failing to include essential photographic evidence that would have given viewers a complete view of. We still have yet to see all the photographic evidence. There's thousands of photos they haven't even released. To the extent the allegations set forth, paragraph 40, or with respect to Netflix denies allegations. On November 8, 2005, 3 days after a Hallbox vehicle was discovered at the salvage yard, plaintiff and Manitowoc Sheriff's Officer James Links, both evidence technicians, were assigned to search Avery's bedroom for evidence more remotely connected to the crime, including pornographic material. Plaintiff and Link were accompanied by Calumet County Deputy Daniel Gacharski. A previous search on the room on November 5th, 2005 yielded handcuffs, leg irons, apparent sex toys, pornographic materials, and a bookcase, but not all items were collected at the time. The public court records addressing these allegations speak for themselves, blah, 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 blah. On November 8, 2005, after materials were returned to the bookcase, the ignition key from the Hallbox SUV was found on the carpet floor next to the bookcase. At trial, plaintiff Link and Kacharski each offered a reasonable explanation of how the key was missed on the earlier search and miscellaneous entries. All three testified they believed the key had fallen from the crack in the particle board backing of the bookcase when materials were returned into the bookcase. They believed Avery hid the key there with plans to retrieve it later and dispose of the SUV. The public records record addressing allegations speak for themselves. On information and belief, defendants Riccardi and Emos were presented during testimony, viewed certain photographs clearly showing the crack in the back of the bookcase. The photographs were not shown to viewers. MAM, in addition, testimony from Officer Tyson, the company officer from the initial search on 11/5, was spliced in order to maximize suspicion of the key, was planted and minimized implausible explanation for how it came to be found. Jerome Beauty, one of Avery's attorneys, asked Officer Tyson the following questions. Have you ever, in order in any other search in your entire career, had to act like a babysitter or a watchdog for officers who were conducting a search? I did not treat this as if I was babysitting. Defendants Riccardi and Emos replaced Tyson's answer with this negative response, no, to a separate question in order to give viewers exact opposite impression of what Tyson in fact conveyed. The public court records addressing the same thing. Upon information and belief, defendants Riccardi and Emos filmed the entire trial, were aware of the full line of questioning concerning the circumstances of the plaintiff and the link finding Hellbox's ignition key in Avery's bedroom, as well as its significance. They chose to fabricate testimony by splicing and omitting these portions not consistent with the false, defamatory account of the facts. And in truth, plaintiff and Link did not plant the key, and many of his apparitions they did are false and have caused irreparable harm to plaintiff's reputation. Same, they deny it. MM's omission disturbs material with evidence and facts. Defendants jointly and severally, and with actual malice, admitted the following evidence and facts as part of their effort to lead viewers to falsely conclude that the plaintiff and other framed Avery for Halbach's murder. Upon information and belief, defendants Riccardi and Demos presented for all court proceedings, including pretrial motions and the entire trial, where all the information was revealed, had their material significant and known facts been included in MAM. Reasonable viewer would have found Avery's guilt obvious and would not have concluded that plaintiff and other law enforcement officers planted evidence to frame him. Avery's DNA was located on the hood latch of Halbach's vehicle. Halbach's cell phone, camera, PDA, computer devices were found in a burn barrel on Avery's property. Several hours after Halbach's arrival at the salvage yard, Avery's nephew witnessed Avery carrying a plastic bag and placed it in a burn barrel where Halbach's electronics were found later. In addition, family friend observed smoke and smell of plastic coming from the same burn barrel. The witness, along with Avery's brother, stated that Avery had changed clothes and showered and was acting strange. The bullet containing Halbach's DNA was linked to the specific firearm hung on a wall over Avery's bed. Avery called Halbach's employer, Auto Trader Magazine, on the day she was murdered, and then asked them to send his photographer to take a photo of her car. He said he was listing for sale in the magazine. Avery asked the receptionist to send the same photographer as he sent last time. Halbach's co-worker stated that she had been somewhat concerned about Avery's approaching her wearing nothing but a towel on the last two of her appointments with him. Avery placed direct calls to Halbach's cell phone before arriving, using star 67 to hide his identity. In the early evening, Halbach's appointment, Avery's brother Earl observed Avery near his truck and trailer with the Avery snowmobile on top. Earl found it strange that he would have removed the snowmobile from the trailer and put it in his garage, since Earl understanding was that Avery was going to take the snowmobile to a dealer and sell it. When asked by police about the Suzuki, Avery said that he had been outside the garage. It had been outside the garage a few days earlier. They brought it home on Sunday, along with the snowmobile. They hadn't been there a few days. They haven't even been there 24 hours. But that's besides the point. But Avery gave several different statements about his interaction with Halbach on that day she was murdered. First, she never arrived for an appointment with him. Second, she did, but he only saw her through a window in his trailer home and did not speak with her. Third, she came inside where he paid her. And finally, that he went outside to her car and paid her for the photo shoot. Avery has history of extreme violence and sexual aggression against women, including beating, strangulation, death threats, attempted abduction, gunpoint, and allegation of rape. Defendants Riccardi and Demos, jointly in concert with the remaining defendants with a reckless disregard for the truth, blatantly and absurdly distorted the nature of the three of Avery's prior crimes. Had the true nature of his past crimes have been accurately portrayed, a reasonable viewer would have been less likely to accept defendants who falsely narrative plaintiff and other local police officers framed Avery for Halbach's murder. Upon information and belief, defendants Riccardi and Demos had access to police reports and criminal complaints associated with each of these crimes and knew of their contents. Avery was convicted of animal abuse when he was 20 years old. Police reports indicated that he had another party poured gas on oil on the family cat, intentionally threw it in the bonfire and watched it burn to death. Episode 1 a.m. Defendants portrayed the incident as an accident and a worst childhood prank. 1986, Avery received a 6-year prison sentence, conviction, endangering safety by conduct, regardless of life, and felon in possession of firearm connection with the running a woman's car off the road. His cousin, Sandra Morris, holding her at gunpoint and ordering her into his car with the apparent intent to rape her. That's not true. They just threw that in there. He was mad at her because she was spreading rumors about him. And when he realized her kid was in the car, he let her go. Emmy omitted significant details and used edited portions of the deposition to cast Avery as a victim and victim of a villain for spreading rumors about him. On September 4th, 2004, approximately a year before murdering Halbach, Avery was arrested for assaulting his fiancée, Jody Stokowski. On arrest and belief, defendants recording music against the police report concerning the incident and knew of their contents. The reports indicated that Avery showed Stokowski, causing her to fall into a chair and hit her head. Avery then struck her numerous times and threatened to kill her. When Stokowski tried calling 911, Avery ripped the phone out the wall before she could report the assault. Avery began strangling her. As she lost consciousness, he dragged her outside to his vehicle. When Stokowski regained consciousness, Avery said, "I should get the gun and kill you." Upon information and belief, Riccardi and Demos had access to the reviewed police reports concerning Avery's arrest for assaulting Stokowski. They knew what Stokowski had reported to the police, but they chose to omit it because it did not fit with their false characterization of Avery, and a harmless individual unlikely to commit a murder. To further their storyline, they portrayed Stokowski unafraid, and supportive of Avery while knowing she was anything but. Defendants also presented material in such a way that defense conspiracy theories received the last apparently unrefuted word, mixing in court experts with out-of-court statements by defense attorneys in an attempt to portray defense theories and speculation as actual unanswered facts. This includes, but not limited to, the following. Jerome Buting, end of MAF 6, Episode 6. One of the things that State argues that it would have taken a wide-ranging conspiracy of so many people to pull this off, and there was just no way that it could be possible. But in fact, that's not true. Really, two people could have done this easily enough if they had the motive to do it. Maybe one even. And the whole argument, well, why would they risk doing this and risk getting caught? You have to understand, they probably would have no fear of even being caught doing this. You know, who better than a police officer would know how to frame somebody? On October 19, 2018, defendant Netflix released the purchase of its subscribers worldwide sequel to MAM, titled Making a Murder Part 2. The 10-part documentary series was written and directed by defendants Riccardi and Demos, with every production, post-production, and editing involvement at Netflix, which also marketed to Spirit of the Answer. Netflix admits that the release to subscribers MAM 2 October 19, and the 10-part series was written and directed by Riccardi and Demos. Netflix marketed and distributed the series, except the explicitly admitted herein Netflix denies allegations, paragraph 49. In an article in the film industry publication known as IndieWire, defendants Riccardi and Demos stated publicly that Netflix was partner from the outset in the production of MAM 2, and that project was fully financed from the start. In the same interview, Riccardi and Demos described the story of Stephen Avery and Brendan Dassey as the gift that keeps on giving. Excuse me. The referred news report speaks to itself and denies plaintiff's characterization in news reports. Despite widespread criticism and public demand concerning the falsity of MAM, and a petition with 2,967 signatures asking Netflix to remove the original series, cancel its sequel because of its false portrayal of only 2,967 when it's been seen by millions and millions worldwide. Defendants doubled down on their baseless claims, evidence planting. The reference news report and petition speak for themselves, blah, 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 yeah. In MAM 2, Episode 1 and 2, defendants present Avery's post-conviction counsel with wholly speculative conspiracy theories and unreliable experiments as convincing proof that plaintiff and his colleagues planted evidence to frame Avery. Episode 1 includes footage of presumed associates of Zellner tossing a mannequin smeared with red substance into the back of an SUV of the same make and model of Miss Halbach's RAV4. Zellner confidently proclaims to viewers that based upon the blood spatter pattern resulted, Avery could not have placed Halbach's body in the trunk of the SUV, as the prosecution and its experts argued at trial. MAM 2, Episode 2 adopts a reliable, convincing evidence, similarly unsound scientific test known as brain fingerprinting, as proof that Avery could not have committed the murder. The content, MAM 2 speaks for itself, yada yada yada. In MAM2, Episode 9, defendants continue the original series false claim that the plaintiff planted evidence by embracing as fact an unverified and unreliable account of Kevin Ramlow. Ramlow claimed that he had a conversation with the plaintiff at the Senex gas station in Mescal on November 4th. A few days after Ms. Halbach was reported missing, the day after she was reported missing, MAM2 repeats claims by Ramlow that the toll police observed a vehicle matching the description of Halbach's SUV a day earlier by the East Twin River Dam, Michigan, at the turnaround the bridge. Ramlow said the plaintiff had pulled into the Senex parking lot and marked police squad with an uniform. Content of MAM2 speaks for itself. Netflix plaintiff denies characterization. Plaintiff was off work, not in uniform, and not in a police squad on November 4th, 2005, nor did he speak with Ramlow on the date or any other time concerning Miss Halbach's disappearance. Plaintiff believes his only contact with Ramlow occurred in September of 2006 when he arrested Ramlow for drunk driving. Netflix is without information and acknowledges deficient informed belief, but denies claims. Upon information belief, the defendants Riccardi and Demos filmed the entire trial and were aware the plaintiff testified he was not working on November 4th. They chose to ignore plaintiff's testimony and adopt as a true Ramlow's unverified, unreliable, false statement to Avery's attorney instead by adopting Ramlow's story. Defendants doubled down on the original series distortion of plaintiff's routine call to dispatch and asserted that the plaintiff participated in the conspiracy to plant Halbach's vehicle on Avery property. Netflix is without information and knowledge is sufficient. Same thing. Denies, deny. Plaintiff repeats and realleges that allegations in paragraph 1 through 56 above is through full and set forth in. Netflix repeats his response to allegation in paragraphs 1 through 56 of this act. Defendants strongly and severely acting with actual malice, defamed, libel, and slandered plaintiff by their creation, production, distribution, publication, and broadcast of the documentary. Answer, paragraph 58 of this act sets forth legal conclusion on which no response is necessary to the extent paragraph 58 sets forth factual allegation. Netflix denies them. 59. Defendants' false statements and communications about plaintiffs include, but are not limited to, the following statements and communications in making a murder broadcast. The statements described paragraphs 27, 29, 33, 40, 44, 48, and X, A, B, above. The statement and communications made in making a murder broadcast, the transcripts of which they attached. Hereto, Exhibit A, the statements collectively communicated to viewing public the false assertion that plaintiff was participant in a law enforcement conspiracy scheme to frame Stephen Avery for the murder of Teresa Halbach. Defendants falsely stated and communicated through their broadcast the plaintiff planted evidence, including not but not limited to Halbach's valet key. So they admitted it's a valet key, her vehicle and her bone fragments, her blood, Avery's blood, and DNA, and order to frame allegedly innocent defendants or strengthen their case against them. The words expressly used in the broadcast are made from defamatory and plaintiff because of the defendant's omission of information that was essential to a truthful depiction of facts, including but not limited to the facts that were omitted, described in paragraphs 27, 29, 33, 40, 44, 48, and excerpts A and B above, among other things, defendants. The statement described in paragraphs 27, 29, 33, 40, 44, 48, and excerpts of A and B above were falsely because the statements did not accurately reflect the testimony of events portrayed and recounted by defendants as a result of the manipulation of the content as described in paragraphs 27, 29, 33, 40, 44, 48, excerpts A and B. Among other things, defendants selectively edited and spliced trial deposition testimony and excluded facts that contradiction their false statements and communications. Defendants knew and had reason to know that the statements were false, but made the false statements and communications described above with actual malice, intentionally, and knowing that they were false and reluctant to discard the statements and communication for true or falsified. Falsity. The purported conspiracy to scheme described through defendants' false statements and communications were a product of the defendant's imagination, and defendants knew that the statement and communications were purported conspiracy scheme were false. Netflix denies allegations set forth. 61. Defendants' false statements and communications described above are not mere statements or opinion, but definitive declarations of fact provable as either true or false. Paragraph 61. SAC for legal conclusion, which is no response if necessary. Extend paragraph 61 for factual allegation. Netflix denies them. Defendants' false statements and communications described above were communicated in the published to viewing public in the United States of America. And additional counties have subscribed to Netflix and or which Netflix publication distributed according to published estimates. More than 19.3 million viewers watched that Making a Murder series from the first 35 days of its broadcast. Netflix admits the distribution of MAMM to the United States, America, and additional countries except to explicitly admitted that heroin. Netflix denies allegation. Paragraph 62. Number 63. Defendants' false statements and the communications described above were not privileged or exceeded the scope of alleged privilege because the defendants and each of them intentionally and knowingly or with reckless disregard for the truth communicated as fact statement were not truthful, accurate regarding the matters asserted that went beyond the statement contained in the record of official proceedings. In addition, defendants added their own factual assertions and intermixed them with the records of official proceedings in a manner to falsely portray the record of proceedings, including but not limited to the manners described in paragraphs 27, 29, 33, 40, 44, 48, and excerpts A, B, and above. Netflix denies allegations. Defendants' false statements and communications tend to harm plaintiff and actually are irreparably harmed and damage plaintiff's reputation, lowering him to estimation of the community and subjecting him to hostility, hatred, ridicule, and determining third persons from associated of dealing with him, and among other following respects. Plaintiff has devoted husband, parent, decorated United States Air Force veteran, defendant, public servant, enjoyed impeccable professional reputation prior to December 18, 2015, when defendants published their false statement and communications about him. Since the time, plaintiff has been subject to worldwide ridicule, contempt, and disdain as a result of the baseless and false assertions in Making a Murder. A Google search of plaintiff's name prior to the defendant's false statements and communications of plaintiff would have revealed 2 nondescript news articles about a routine local crime plaintiff who had a role in the investigation. The same search now yields more than 1.8 million hits, nearly all of them painting plaintiff in a negative light. YouTube videos about plaintiffs received nefarious role in every case and produced the result of the defendant's false and communications. National and international news and entertainment media have published hundreds of articles, television, radio segments adopting and publishing defendants' false and defamatory statements. Communication about plaintiffs' social media, including Facebook, Twitter, YouTube, and Reddit, are all replete with the threats and insults directed at plaintiffs because of his baseless accusations against plaintiff made by defendants. Countless tweets, memes, insulting and threatening social media posts portraying plaintiff as a corrupt police officer and cooperative in framing Avery has been posted online. Defendants jointly, severely, and compounded and aggravated that the harm of the plaintiff's reputation by deliberately ignoring critical analysis in the aftermath of the release of the Making a Murder broadcast. Thorough, careful, object analysis by some members of the public and a few journalists revealed that the series had badly distorted the facts. Upon information and belief, defendants were aware of the critical analysis of could have been taken action to prevent further harm of plaintiff's reputation by admitting their distortions and omissions of the fact when above mentioned articles were published in the sequel of the original series, Making a Murder 2. Instead, the actual malice defendants doubled down, distorting and omitting additional facts to bolster their pre-obtained conclusion that plaintiff participated in allegedly framing. Netflix denied allegations. Defendants' false statements and communications were made in international discredit the plaintiff's result rights and will toward plaintiff as a result of other bad motives, including but not limited to defendant's defamation, determination to slant and distort the truth, sensationalize the facts and circumstances surrounding the investigation of Teresa Halbach's murder and the trial of Steve Neighbor for the murder in order to exploit those events and circumstances the defendants own economic benefit at the expense of the individuals who were involved in the investigation and trial. Netflix denies. As a result, there will be damage to plaintiff's reputation was caused by the defendant's false statements and communications about plaintiff. Plaintiff is entitled to damages in total amount to be determined by a trial, including but not limited to general damages, compensatory damages, special damages, including but not limited to lost wages, punitive damage. Netflix denies allegations. Netflix denies allegations and proven count 2, negligence pursuant to the court's May 26, 2021 order. Negligence claim is barred from the First Amendment and was dismissed by Court 176 at 15, count 3, intentional infliction of emotional distress. Plaintiff repeats realleges that the allegations of paragraphs 1 through 76 above through fully set forth herein. Netflix repeats the response of paragraphs 1 through 76. Defendants act intentionally and recklessly in making the statements and the communications described in paragraphs 27, 29, 33, 40, 44, 48, and excerpts A, B, and above. Netflix denies allegations. Defendants' actions and conduct described above were extreme and outrageous. Defendants should have reasonably foreseen that their false rendering of plaintiff as a corrupt police officer would allegedly help frame the allegedly innocent man would lead to popular outrage threats resulting in extreme emotional distress. Netflix denies allegations. As a direct result of the defendant's actions, conduct, communications, and statements as described above, plaintiff have received serious and ongoing threats to his family and family safety. Plaintiff has been subject to recorded telephone threats, their sheer volume which will fill the capacity of 28 compact discs. Plaintiff has received numerous late-night telephone calls in which callers screamed profanities and threatened to do him physical harm. Avery sympathizers have threatened to kill plaintiff and members of the family, kidnap, sodomize him, and gang rape plaintiff's wife. Photographs of plaintiff's children have been posted online by hateful viewers influenced by defendant's communication and statements. Plaintiff had more cautious and guarded in nearly every aspect of his life, including making travel plans where he and his wife can eat in public. And due to the threats of violence and hostility against him, he has been caused by defendant's statements and communication. The plaintiff is required to maintain a state of hypervigilance at all times and constantly be alert of potential danger to his family and safety. Netflix denies. As a direct result of the defendant's actions, conduct, communications, and statements and foreseeable consequences, therefore, plaintiff suffers and has suffered from severe emotional distress and anxiety and exhaustion. Netflix denies allegation. As a result of the foregoing, plaintiff is entitled to damage the total amount to be determined by trial, including but not limited to general damages, compensatory damages, special damages, including not limited to lost wages, and punitive damage. Netflix denies. Wherefore, the plaintiff respectfully requests the following relief. Damage in an amount to be determined at trial, attorney's fees and costs incurred prosecuting this action, and such other further relief may be allowed by law. Netflix denies the plaintiffs entitled to say any of the relief encumbered by the wherefore clause. Netflix respectfully requests that the court enter judgment on behalf and award Netflix such other further relief as the court deems just. Affirmative defenses. Without assuming any burden of proof that would not be otherwise bear, Netflix asserts the following defenses, all of which are pleaded and alternative. First defense, the SAC fails to state a claim upon which relief may be granted. Second defense, the SAC is barred from a whole and part of the First and 14th Amendments to the United States Constitution and Article 1 and 3 of the Wisconsin Constitution, and or by Article 1 and 1 of the California Constitution, and by other common law. Third defense, some of all the challenge statements are not of concerning the plaintiff, and any allegedly defamatory statement of the concerning plaintiff is true or substantially true. The plaintiff cannot carry his burden proving that they are materially false. Some of all the challenge statements are not defamatory or defamatory per se. or some of all the challenge statements are not reasonably capable of defamatory means attributed to the plaintiff. Some of the alleged statements are reasonably capable of defamatory. I read that already. Sorry. Some of all you challenge statements are non-actionable under the First Amendment of Wisconsin and California laws because they are pure opinion. Eighth offense, some of all the challenge statements non-actionable under the First Amendment of Wisconsin and California law because the opinions are based upon disclosed facts. Some of all alleged statements it's the same thing. 10, same thing. 12, Netflix did not publish or distribute allegedly defamatory material with constitutional malice, actual malice. 14th offense, Netflix acted without requested degree of a fault required the U.S. Constitution and has conducted related statements in the issue. 15th, Netflix did not intend to convey implications alleged. Netflix did not endorse implications alleged. The SAC is barred in whole part by the irreparable harm doctrine. Is barred in whole and part of the extent of the SAC arises from the conduct not attributable to Netflix, and the recovery of the plaintiff should be reduced to proportion to the fault of the others. It is barred in whole and part because without admitting the plaintiff entitled to any recovery, and every recovery which plaintiff is entitled must be reduced by reason plaintiff's failure to mitigate his damages, if any. Plaintiff's SAC is barred in whole and part because plaintiff has not alleged special damages sufficient particularity and they cannot prove special damages. Plaintiff is not entitled to recover any punitive damages because of the SAC and in each cause of action against Netflix therein, and each of the relief therein fails to plead facts sufficient to support the recovery of punitive damages. 22nd offense, plaintiff is not entitled to recover any punitive damages because any such award would violate Netflix's rights to due process and are equal protection under the law, under the United States, Wisconsin, and California constitutions. 23 offense, plaintiff impermissibly attempts to run the requirements of libel law by labeling his claims as unintentional infliction of emotional stress. Dated June 18th, respectfully submitted by James Friedman, Matthew E. Kelly, Lita Walker. So basically there was two documents. The first one was Netflix asserting, well, I should say, Colborn asserting everything that took place. And the second document we have, which is the one I just read now, is Netflix responding to all the claims that Colborn and his attorneys are claiming. So now we just gotta wait for the state to respond, and I'll bring that next. Y'all have a good night.